Welcome to DePaul University and our sixth Clifford Law Ethics Seminar. My name is Bob Clifford, and I'm probably the Illinois State Delegate for the American Bar Association House of Delegates, and in that role, that's kind of how I got started on hosting these programs. They actually started with wanting to, when CLE was passed, I put together a program for my own office, and then said, well, why aren't we inviting people? And then why aren't we inviting people? And the next thing you know, we have all this going on, and it's really been a lot of fun for us. We're committed to raising the quality of the practice of law in our state and promoting civility, which I think is a very necessary part of what we do as lawyers. You're going to hear some interesting stories about that today, I think. This is a timely program. It's the ethics of witness preparation for deposition and trial. And it's another step in, I think, the direction of lawyers getting it right and representing our profession well with the public. So for the next 2 hours, our esteemed panelists will take you through a variety of hypotheticals. You have the materials before you. I'll explain those in a minute. But these will help provide you with a better understanding of the important part of the litigation process. We have with us today the Honorable Kathy Flanagan of the Circuit Court of Cook County. She's joining us. Judge Flanagan serves as the supervising judge of the motions section in the law division of the Circuit Court of Cook County. She's been on the bench since 1988. Next to her is Professor Steve Saltzburg. He's a dear friend of mine and a colleague from the ABA, where I initially met him. He's worked with me as an expert witness and consulting on ethics and evidence, and actually it started with the 9/11 case that I handled. And Steve is extraordinarily active in the American Bar Association House of Delegates and with the ABA in general. He's a professor at George Washington University Law School in the nation's capital. He serves as a special master in many cases, most recently settling over 28,000 cases in a drug products case, and currently been appointed a special master in 3 other cases, and he's a practicing lawyer, and he serves as an expert witness. He hits to all bases, both in academics as well as in the practice. So I think you'll enjoy them, and I'll moderate the program and try to keep the discussion among us lively. The materials that you have before you, number one, and for those of you who are here, there's a hard copy, and for those of you on the web, I know that you can download the same materials. So to learn more about the topics and the articles from the panelists, including one of my own, you can go to our website at cliffordlaw.com. And then also throughout the program, we will be doing have an engaged discussion with questions from the audience here live, and questions coming to us live off of the web. And so let me get this going and turning it over and to my friend and colleague, Professor Saltzburg. How about Steve? You pick up the ball from here.
You want to do our first of our?
Nah, you know what I'd like to start. What I'd really like to start with is an example that I have from being a young lawyer. I saw a weathered, esteemed lawyer one day. Someone came to him and said, "I represent this lady, and she's talking about the scene of the occurrence, and she doesn't know what color the light might be." And he says, "Wait." He goes in and, "Madam, if the light was red, you lose. If the light was green, you win. Madam, what color was the light?" Can he do that?
Want us to respond? Actually, it's the judge and I were just talking about this. Absolutely, you can do that. One of the most, I think, common mistakes that we make, and I think law teachers are as responsible for this mistake as anybody. The mistake is to think that people who come into your office somehow know what's relevant and what kind of problem they have. You know how law school, all of you in law school went through, you took a different course in torts and contracts, and so on. You always knew what kind of problem you were dealing with. And it wasn't till the bar exam that somebody handed you a set of facts and didn't label it for you as a contracts issue or a torts issue or whatever. And you had to sort of figure out what was going on. Well, when people come in and say, "Here's what happened to me," they want you to tell them whether there's any chance that they have some form of relief available to them. And it may not, you might think oh, everybody would know this, what it really matters in an automobile case. Everybody would know that's what the most important thing is. They don't know. They don't know what you're looking for, and you can tell them, well, tell me what happened. And all of you know this from interviewing people. They'll tell you things, and most of the stuff they have to tell you really isn't very important. And the things that you really want to know, you really have to probe for. And then you have to probe some more because they'll often tell you what they think you want to hear, which very often is not actually accurate. And when you probe, and you actually sometimes have to tell them, look, just what Bob said. It boils down to this. It's very simple. Just tell me, was it red or was it green? And once you know, you'll be able to say, well, you have no case, or I think we may be able to move forward. And
well, then on a related front, Judge, and actually one of the very first questions that came into us today over the web was whether a lawyer would be permitted to prepare a witness in such a way that the witness was given a specific text to state as the answer in anticipation of a deposition question, so that so long as the answer is truthful, can the lawyer give the client a specific text, yes, it was green, if you will, to give as an answer? Is that proper?
Well, I think as long as the witness is answering truthfully, and you're just marshaling the evidence or preparing the witness for what the questions are going to be, and as long as you're not telling the witness to change their version of events, I think it behooves you to prepare a witness for a deposition.
So then, let's turn to, then if we could...
Don't leave that one quite yet. I think she wasn't done.
I apologize.
No, I just wanted to say one thing, and the professor and I were talking about it before, as he alluded to. In my job, I read an awful lot of summary judgment motions, and I read an awful lot of depositions of clients, both plaintiffs and defendants. I am astounded many times as to the lack of preparation that the witnesses undergo based on how they testify. Their lawyers are throwing them up for depositions with no preparation or with no preview of what the anticipated questions would probably be, and they leave their clients floundering. And even on a simple slip and fall, the clients are answering questions that just indicate there is absolutely no preparation done whatsoever prior to this deposition. And then it leads judges to believe that many times when you take a client as a plaintiff's attorney or even as a defense attorney, you need to tell them what the law is. You need to tell them, as the professor said, what the elements are of your cause of action or what the elements are of your defense from the get-go. You can't wait until the end of the case and then have some judge take the heat for you when you've had a bad case that shouldn't have been brought at all.
But can we stay on this one point on Bob? Let me ask you this question. And by the way, I have no power to compel you to answer. It's not like there's a subpoena out here. But curious, and nobody will remember who raised his or her hand about what. How many of you write out questions and proposed answers for witnesses and give it to them and see, assuming that they think they're accurate, you practice that way? How many of you do that?
In the room, I'd say about 5%.
Yeah, small number. My own view is it's a really bad idea, and that the 95% of you don't do it. It's not an ethical issue at all. We're actually, and it's important, I think, that we distinguish two things here today. That is that which you can do ethically and that which is smart lawyering. And why do I say it's not a good idea? Because if you don't do this, you ought to be doing it in your depositions. You're deposing a witness, what you ought to ask that witness is, did the lawyer here write out questions and answers for you to look at before your testimony today?
Can you do that with my client? Wait a minute, that's a privileged communication between me and my client.
If it's, we'll go to the client next. Suppose it's an ordinary witness.
Okay.
You don't have attorney-client privilege. You can try to argue work product. But as you and I were talking earlier, query whether what you disclose to somebody outside the lawyer team is going to waive work product protection. Point is, if in fact the answer to that question under oath is yes, what do you think if you ever have to go to trial? What do you think judges and especially juries are going to think about the credibility of a witness that you have to write out her answers for. I think they're going to think that's a really honest person. Now, you might think, well, they'll understand that the witness was nervous and all that thing. No, they're going to think that what you did was script them because you were afraid of the truth and you were afraid they might say something that actually was truthful that you didn't like. The danger in ever having disclosed, and by the way, suppose you then ask the witness, do you still have a copy of that? And the witness says yes. And you say, I want to get back. I'd like to have it. And the other lawyer says, work product, you can't get it. And I say, well, I want to call the judge. And I call you and say, Judge, here's where we are. The witness has had questions and answers written out and has admitted it and has a copy. And I'd like to see it. Can I see it?
And the judge would say yes.
And there you go. And the moderator says, we move on. But related to that, so the whole idea here is you have academia and practice, you have the bench, you have practice, and about trying to teach and talk about what's the right way to do it ethically, what's improper, but also in the practice, what's an ethical way to prepare. Certainly for a lawyer to take the witness to the scene, to go through the events at the scene, to refresh memory. All of that is proper. It's certainly proper to take your witnesses to the courtroom in an empty courtroom and have them sit on the witness chair to get comfortable with the surroundings as part of their preparation. And those are things that are proper and ethical to be doing.
Last point that you asked me about client. What if it's your client?
Yes.
Can I just mention that for a second? The federal rules of evidence, and a lot of federal judges are pretty tough about this, make clear that anything that you use to prepare a witness to testify is something that may have to be disclosed under what federal rule is 612. It's the rule on refreshing recollection. And most federal courts don't draw any distinction anymore between preparing a witness and refreshing recollection. And so there's a whole series of cases that say you waive both attorney-client privilege and work product if you show something to a witness in preparation for the witness's testimony, even if it's your client. So it's a danger. Now, state court, how would state court be on that?
Well, I mean, my interpretation of that would be anything that is to be protected under attorney-client privilege, one of the elements is that the information or document or writing is intended to remain confidential and not disclosed to anybody else. So if you're having a witness testify or a client testify about certain things, that is not intended to remain confidential. They are coming forward and testifying about it at a deposition. So if that's going to be confiscated in my room.
All righty. We have a question in the audience.
Professor Saltzburg, I'd just like to ask if he handles more plaintiff's cases or defendant's cases.
Question to the professor about whether he handles more plaintiff or defense cases.
Lately, most of the cases I've been involved in, you can't distinguish. For example, I have a patent trial. I'm going to try a patent case in Delaware. We happen to be the plaintiff, but you can't tell the difference in those cases, right? I mean, the claims go back and forth. As a special master, I've been neutral. Bob mentioned I've been serving federal courts. I did settle 28,000 individual lawsuits against AstraZeneca, state and federal, and now I'm serving, I have to admit.
That's the drug Seroquel.
That was Seroquel. Judge Herndon, Chief Judge Herndon in the Southern District of Illinois called me and asked me if I could do the same for his Yaz and Yasmin cases. And I had to say, what are they? Which really dates you, when you have to say that. And
then he had to ask where East St. Louis was.
He said, I did. He said birth control pills, and so I'm now doing those. So I'm kind of in the middle.
Okay. All right. Hypothetical number one, if I may.
Yes.
And I'm going to bring up, of course, this section in preparing of witnesses is that you're representing a company that's been charged with sexual harassment of 3 former female employees. And in the course of your investigation, you're interviewing various coworkers, supervisors, and managers. And now this is a question of style. For all those of you who saw the movie Anatomy of a Murder with James Stewart and George C. Scott and Ben Gazzara, Eve Arden, all those great stars, is probably the finest trial movie out there ever. but in that, and Steve, I think will speak to that, but what's the right way to go about asking about policies, saying what's good practice, bad practice? In this example, you're kind of telling somebody the answer in your question versus asking them a true question. Professor, what's the rule of engagement for preparing the witness there?
In the materials you have, you'll see that we've cobbled together a bunch of excerpts from people's writing about how you're supposed to do this, the ideal way. And at least in theory, a lot of the writers say you should go in with an open-ended question. Tell me everything about the company's policies on sexual harassment. And then you should press and going forward and not tell them exactly what it is you really want to know. Well, I don't know, you all have experience with this. A lot of people really find that you're wasting their time. And what they want to know, particularly people who are higher up in a company, is what do you want to know from me? I mean, and your answer is, I want to know whether you had specific policies on sexual harassment. I need to know. And the more specific they were, the better it's going to be for you and for me. So tell me. Now, one of the things that some people worry about is they'll hear that and they'll say, we have very specific policies. Well, that's not going to be the end of it. Because your next question is going to be, what were they? And where are they? And I want to get my hands on them. And clients will tell you things that aren't true. We all know that. But when it turns out that they can't back it up, then you'll have to reassess what's in your case. But personally, I've got no problem with a lawyer who's especially dealing with people who don't want to take a lot of time. When the lawyer goes right to it and says, this is what I want to know, this is what I need, tell me, is it this or is it that? It's really your red light, or green light.
Okay, very good. Now, in the same hypothetical, where once again that we're dealing with employees who are accusing a company that's being accused of sexual harassment by former employees, that in the course of your investigation you come upon various witnesses who have facts relevant to the occurrence and the event, and witness number one had something to say that you like. It's positive. You're the company's lawyer. Witness number two, on the other hand, damages the company. What about, is it proper to then re-interview them again, and number two in particular, and tell them what number one said in order to try to get number two to have a refreshed recollection that's more in line with what the company has to say and desires? And what are the rules of engagement? Now, in the materials, we have their section of certain modern rules that are being cited for you, and if anytime you want to refer to those, please feel free to do so.
So I bet everybody in the room would come up with the same answer here. You're an attorney. You've got two witnesses, and they're both witnesses who claim to have personal knowledge. They're both employees of your company, and they have conflicting recollections of what happened. Now, it could be, we got three possibilities, right? That witness one is right. Second possibility is witness two is right. And the third possibility is they're both wrong. And you got no way of knowing early on which of those possibilities you're dealing with. And you have an obligation to the company to try and figure out which it is. Now, it really doesn't matter where you start. I mean, you certainly are going to be happy that witness one seems to be favorable. But you're going to end up having to deal with this somehow or other. You're going to end up having to see whether one of these witnesses will change his or her mind when you expose them to the fact that somebody else who was there, who also has personal knowledge, saw something or at least recalls something different. And I not only have no problem with it, if you don't do something about witness one and witness two to try to see whether you can figure out why there's a difference here, who's right, and whether you can figure out maybe there's a piece of what each have said that's right, then you're not doing your job for the company. You certainly can't just say, oh, I'm stuck. I'll use one and the other side will use the other. That's just crazy. You're going to press and probe and try to figure out, whether what happened is good or bad. By the way, if it turns out that witness one is wrong and witness two is right, you need to know that. The earlier you know it, the better. Because then you're going to probably start talking settlement, because the last thing you want to do is have these people deposed.
And which brings us to, if you look at hypothetical 3, it's again staying on the same fact pattern, but now can you bring those two witnesses together and say, okay, you guys, you both can't be right here. We're talking about the same set of operative facts, how about if I leave the room and come back and you two tell me, I'll be back and you tell me which one of you is wrong, which one of you is right. Or you try to flip one of them. Can you do all that?
Same thing, right?
Yeah.
Just a different version. Actually, I think this can be particularly productive. And I don't think you have to leave the room. I think what you want to do is say, tell him what you told me. And then, tell her what you told me. And now let's think about this. Now, you might ask him, where were you when this conversation actually occurred? Who was closer to the conversation? What were you doing at the time? Is there any reason that you have particular recollection of this? I mean, does the fact that each of you has heard the other cause either of you to think that maybe you got this wrong? I mean, you're going to want to do that. And is there anybody else out there that we ought to be talking to who might also know something that would try to help you figure out what was heard? And people, we know, will change their minds. I mean, I know it's true for me. You talk to somebody, you recall something, and then somebody says, well, wait a minute, don't you remember this? And suddenly it jogs your memory. And you say, you're right, I was thinking about the wrong conversation. Now that you've jogged my memory, that you're absolutely right. And that can go either way, of course. But one of the things that I think we want to do, happens to be a company we represent, but it wouldn't matter whether it was an individual or a company. We want to be sure about, when we're talking to witnesses early on, is that we get it as right as we can, because if the witnesses are going to be good for us, that's great. Then we're going to have pretty confident posture going forward. It's going to affect how we approach settlement, how we approach discovery. If things are going south on us early, and we know that as depositions start getting taken, the other side's going to get a lot more confident, then our settlement posture, our whole approach to the case is going to be different. And we're the ones who need to know that. We're the ones who need to make tactical judgments about that. And certainly we should never be scared by the fact that witnesses have different recollections. They all do.
Okay. And so, now as you're working through this case, you start to get into the detail of what exactly are the claims, and you interview one of the supervisors as described in hypothetical 4, and that supervisor tells you that she heard one of the people who's being accused of this harassment screaming at the top of his lungs at one of the plaintiffs, and on behalf of the company, can you kind of get in there and say, well, there are screams and there are screams. Was it a loud voice, or wasn't it just really just some yelling or something? I mean, screaming, can you start to fudge the words or give them a better vocabulary? What can you do about that? Is that proper?
Well, the ethical rules are quite clear on this. I mean, the ethical rules are quite clear that you can't attempt to offer false testimony. So the line is, you can ask a witness whether these words accurately reflect what the witness is trying to say, as well as the words the witness originally chose. And if the answer is yes, then you're on the right side of the line. If a witness has given you a statement and you say, are these words equivalent, or are they accurate? The witness says, not really. And you say, well, it would be much better for us if you use those words anyway. That's crossing the line. Right? Would you agree?
Yes, absolutely.
That's false testimony.
And when it gets down to actually deposing these people, they should be prepared for the questions that are going to come from the opposing counsel. They shouldn't be surprised at a deposition with a question such as, Professor, would you be at all surprised if I told you that Mr. Clifford in his deposition testified completely opposite to your version of events? That witness should know that. That witness should know it's coming, so they aren't surprised and so they don't do something that can really injure your client. The other side will find out about it if every one of these witnesses is disclosed as a person with knowledge. So it's better to get on the front end of the problem and at least have everybody prepared to address it. Nobody is ever going to be in lockstep with every version of every event. It just won't happen.
So, Judge, are you saying that it's okay for me, if I represent someone, to take an assembly of whether it's a testimony or sworn statements or recorded statements, and give them to another witness to read and prepare and know about so that they can be aware of all the other information in the case?
I think they can be made aware of it, and they should be made aware of it. Not that it should be used as a weapon or a suggestion even to change their testimony, but I think they should be aware of it.
Professor?
Well, I've no doubt that you can ethically do it, but we do have this practical and tactical consideration, which is if the witness is asked what documents were you provided in preparation for your deposition, the witness is probably going to have to answer that question. And and by the way, you're probably going to, if it's the typical deposition, aren't you going to, if you haven't gotten them already, aren't you going to, in your subpoena, you may have subpoenaed, right, all documents the witness has used in getting ready for the deposition, and suddenly you're going to see that the witness was shown statements by other witnesses in the case, and you're going to be asking about that. And whether or not you're going to ask the witness whether the witness has changed what the witness previously said about what happened in light of reading these other statements. And you're going to run the risk at some point that the suggestion will be there that you try to alter the witness's testimony. But on the other hand, as the judge said, if you don't do that, and the witness is asked a question that comes out of the blue, and the witness is unprepared, the witness sometimes doesn't know how to respond and says something that's really damaging. As long as you're comfortable with the fact that it may come out that you gave the witness stuff to review, and you've trained your witness to say, when asked, why were you given this? What's your understanding? And the answer from the witness is, counsel wanted me to be prepared to address what other people said as well as what I said, so that I wouldn't be surprised in your questioning. I think you're probably okay.
And that's the answer you gave him.
Yes.
All right, we have a question on the web.
We have a number of questions on the web, and Brian is asking a consensus of the panel. Does sharing work products such as the outline of testimony or a summary of other witnesses' testimony waive the attorney-client privilege and make the information discoverable?
Well, first, if I could just take this. First of all, you're talking apples and oranges. Work product is a privilege that belongs to the attorney, and it concerns documents that reflect mental impressions, trial strategies, analyses, etc. of the attorney. Okay? So that's something separate and apart from the attorney-client privilege, which is a protection against written or oral communications, the context of written or oral communications between a client and an attorney. So if you're talking about witness summaries, whatever, I don't, if you turn that over to a person and let them use that to prepare them for deposition, yes, that's a waiver. Absolutely.
I agree. Professor, any? Same thing. Okay.
I think a general rule is, these days, whatever you show a witness in preparing a witness, just know that may end up being disclosed.
There you go. Next question.
What about group meetings of witnesses? How should that be handled? I think you touched on it a bit before. We know maybe two, but they're asking when you have a group of witnesses.
Putting together a group of witnesses?
In a room.
Well, certainly
That's
from a
question
practice
from Judy.
perspective, I think, let's assume that they're non-clients. I think you waive whatever goes on in that room is fair game for inquiry. And even if they are clients, well, this is a very interesting question I wanted to get to, so maybe this is the way to get to it. There's this new thing, not new thing, I guess it's been around for a long time, but it's becoming more and more in doubt, these joint defense agreements where, defendants and their counsel they may well be in the same case, and they may not even be in the same case, but they're litigating similar cases in different courthouses, are entering into sharing agreements of information and claiming a work product privilege associated with all the stuff that lawyer A in California gives to lawyer B in New York, saying that the plaintiff's not entitled to that information and there's no cross-representation or anything like that. How do you answer that, Professor?
Well, I believe in joint defense agreements, and both sides. We call it joint defense, but joint plaintiffs agreements. I believe that they're important when you're litigating cases to make sure we don't end up the victim of a divide and conquer strategy. But the question you asked points out the dangers in just think about this, for example. Bob Clifford and I have a joint defense or a joint arrangement, joint client arrangement, and he gives me certain documents that would be covered by his work product privilege. I show them to my witnesses. My witnesses are then deposed, and one of the questions is, what documents were you shown? And the witness answers the question, and the lawyer on the other side wants the documents. I have to tell Bob I've now had to disclose his documents that he gave me under our joint arrangement because I used them to refresh the recollection of a witness. Now, he's not going to be happy with me, but I was concerned about a fully prepared witness, and it's one of those things I think that most of the joint defense agreements I've seen don't deal with at all. It's just not there. All efforts are made to say we don't waive anything by sharing and all that. But in this area we now talked about, when you show something to a witness, to prepare a witness to testify, whether you created it, I, or Bob created it, I now put his information at risk. So,
Pam, could I go back to that question about the group meeting?
Yes, sure.
Group meeting of plaintiffs, what issues come up there?
Well, a group meeting of plaintiffs, I'm not sure that there would necessarily be a problem, but when you're representing a corporate entity, like the city of Chicago or the CTA or one of those things, if you go out and you have a joint meeting, the attorney-client privilege only protects communications between the lawyer and the control group. So once you have people present at this joint group meeting, and that group includes people outside the control group of the corporate structure, you're gone. The presence of a person that is not inside the control group destroys the privilege. So be careful about when you are making meetings with, a group meeting. Be aware that if you want to claim the privilege, there better not be anybody. You can meet with the control group separately, and then you can meet with the employees separately, but once you get them together, that's going to be a problem with the privilege.
And just from a practice point, and then maybe we move on from this one, but the idea that any time that you put together factual witnesses, clients or not, control group or not, into the same room to try to talk about a single event that's in litigation, just let a red light go on in your mind and proceed with caution, and maybe proceed with counsel, maybe properly get an ethics counsel on board, because you're really on dangerous ground, and consequently you subject yourself to a negligence claim against you for screwing up the case because you didn't know the ethics and didn't know the rules around it.
Can we have a little twist on what we just talked about?
Sure.
I mean, I know you'll appreciate this, but it's not really an issue that on your side of the case you usually get to worrying about. And this has to do with when you are representing the corporation and you go to interview the employees. And I don't care whether it's an officer, control group person, or whether it's an ordinary employee. Ethical question for you is, what do you have to do to make sure that you don't create an unintended joint client relationship? Basically, I mean, so I'm clear on this. If you're hired to represent the company, generally speaking, what the company wants is the freedom, right, to make any deal that works to the company's advantage, even if it hangs the employees or the officers out to dry, if that's what they choose to do, right? So the privilege the company wants is a company privilege, which means that if you obtain statements, the company wants the right, to the greatest extent possible, to claim privilege when it's in the company's advantage. And if they can strike a deal with the government, the FTC, DOJ, Attorney General of Illinois, if they can strike a deal, they want the ability to turn those statements over if it'll mean the company's off the hook and they can lay the blame on an individual. And that sounds terrible, right? But that's the way attorney-client privilege works. That's what you're being called upon to do. And so one of the great ethical issues, challenges for a lawyer is, how do you make sure when you go out there that you don't screw it up so that the employee or the officer says, well, wait a minute. I was sure that was my lawyer that I was talking to. And if a reasonable person would have assumed that the lawyer, represented them as well as the company, you then have a joint client relationship. And what does that mean? It means you can't hang them out to dry based on their statement, because you can't turn a statement over to anybody, any third party, unless both joint holders consent. So, what do you do? And what are you doing out there? I mean, my advice has been for 20 years now to, first of all, give the equivalent of Miranda warnings to everybody that you're interviewing, which is, I do not represent you. I represent the company. What you tell me may be privileged, but it's the company's privilege. And you have no expectation that what you say to me may not be disclosed to third parties.
But isn't there one more thing that you ought to say to them, and that is that you don't have a duty to speak to me, and then if their own individual rights are at risk, don't you as a lawyer have a duty to tell them about that so that they can lawyer up on their own, or have the demand that the company get them a lawyer?
Wait, I'm glad you asked me that, because I want to answer that just in 1 second, okay? Before I get to that one, I've now gone further in these warnings, and I believe that, in fact, not only should you do it orally, but you should have a written statement and ask them to sign it. If they won't sign it, then you got a problem, because you always have the risk that it's their recollection against your recollection, unless you're also recording the statement. Now, the question Bob asks is, do I have to warn them that they don't have to talk to me? My answer to that is absolutely not. Indeed, suppose they ask you the question directly, do I have to talk to you? The answer that you will give in many instances is, I can't make you talk to me, but I can tell you that the company does reserve the right to fire you if you refuse to cooperate with me. Now, I say that, by the way, fortunately I don't have to do many of these investigations. I just get to talk about them, because it's really a horrible thing to be out there doing, right? You're saying, I want you to know I can hang you out to dry, and that's what the company wants. And basically, if you want to ask me, you don't have to answer my questions, but, you have to worry about your job.
And the company has to worry about a wrongful discharge case.
No.
Why not? Yeah. Why
Right.
not? Why not? You're threatening me. You're saying, talk to me, or I'm
No.
going to get you laid off.
I want to be clear. Never should the lawyer say, I'm threatening to fire you. All I'm saying is the company reserves the right to take any action if you refuse to cooperate with the company.
And the company has the right to do that.
But the related question they ask you is, do I need my own lawyer? That's usually the next question. Do I need my own lawyer? And what do you say?
What kind of cases are we talking about here? Where the company's being investigated for
price fixing, Foreign Corrupt Payments Act,
Securities Act,
Acts. Where these people have knowledge, and sometimes they are the players. Sometimes they just are witnesses to the events. So but the question is, do I need a lawyer? Now the law is very clear here, and what your answer has to be on that.
So how would that work with a municipal corporation like the City of Chicago or the CTA? Say it's a bus accident and the driver is being questioned, and the CTA is the entity that hired the driver. Does the lawyer for the CTA have to go and advise the driver that they're entitled to get an attorney?
So answer. The question is, when they say to you, do I need, that's the answer, and they often put it that way, do I need my own lawyer?
But they usually don't. They usually rely on the CTA attorneys or the City of Chicago Corp Counsels to, number one, represent them, number two, take care of all the discovery and whatever, and prepare and present them for deposition.
I think a municipal entity is the same as a corporate entity in terms of lawyers' responsibilities and concern about who the lawyer actually represents.
Okay.
But to answer the question, you got to be very careful you don't answer that question. If you can't say no, you don't need a lawyer. You can't say yes because you're not entitled to give legal advice to somebody who's not your client. If you give legal advice, you may be creating a joint client relationship again, which is what you don't want. So what is your answer to that question? Your answer is, I am not permitted to give you an opinion about whether you need a lawyer. You'll have to make that judgment. I'm just entitled, but I will tell you, you have every right to obtain your own lawyer, and that you should obtain your own lawyer if you believe that's in your best interest. That's what you want to say.
All right, some questions related from the web.
Yes, we have a few questions coming in regarding when you have a few people in the room together again, and they're asking that, first of all, how does it impact the credibility of those witnesses when it comes out later that they worked it out jointly in a room, and can they be forced to disclose that this occurred as to the way they worked out their differences?
Well, I think somebody could ostensibly use the group occurrence as somewhat of a rehearsal and all circling the wagons and getting the version of events in line with each other. That could be used as some sort of, impeachment.
Absolutely. In fact, one of the things that I wanted to make sure got out on the table today was that whenever you're dealing with the preparation of witnesses and the interviewing of witnesses, litigation credibility is the term that I use, is always at issue. And if you engage in missteps, that stuff in these days is just going to come out. And it calls into question the quality not only of the representation your clients are getting if you fumble, but it's also calling into question the merit or lack thereof of their case and the defense. Steve?
Yeah, I do agree. My certainly advice is you always should interview witnesses individually first, and then it's the rare case. But sometimes you will bring them together because you have no other way of trying to reconcile things. But it's never a good idea to bring 10 people together and try to figure out exactly what occurred, because you don't get candor. You often get echoing, and what you really have to worry about is when somebody finally pulls them apart and starts deposing them, that they're going to end up with very different stories and that you didn't realize it.
Right. One more question from the web.
From the web for Judge Flanagan. If an attorney represents their clients' friends or families informally, and during depositions they advise them how to instruct the witness if they should be answering for depositions, would this type of informal representation agreement hold up if the defendant subsequently brought a motion to compel answers to certified questions if she claimed that they were protected by the attorney-client privilege during this deposition?
It's a heck of a question.
What was the question, I guess? Well, to begin with, here, informal representation, I don't know that I don't know that there is such a thing. That's number one.
No, I think you have to first establish if the lawyer is going to be presenting a family member for a deposition, you have to clarify with that witness just what the nature of the representation is. If you're merely accommodating the scheduling of the person because it happens to be a family member, but not representing them for the deposition, that's one thing. But if you're going to represent the family members or the boyfriend or the girlfriend or whatever, as an accommodation, you should make sure that if there is going to be an attorney-client relationship such that the attorney has standing now to object or instruct a witness not to answer, you better have a very, very clear-cut relationship established before the deposition. Okay.
So let's turn, if we can, to a new area. When you're preparing a witness, and this is kind of along the lines of going back to the anatomy of a trial, when you have a witness who came out and said, well, you haven't confessing to, I acknowledge that there was a murder involved, but I don't remember anything. Here in hypothetical 6, we have somebody who you represent, a lawyer whose license is subject to suspension because of alcohol abuse, and in the course of meeting with your client, you could tell that that their recall of events of the AA meetings is iffy. So you start to spend time with them going over what it would be that they would learn in an AA meeting, so that they could kind of pretend that they were there. Can you do stuff like that, Professor?
So let's see how we all feel about this one. You get the facts. A lawyer is out on suspension because of alcohol abuse, and bar has ordered the lawyer to go through Alcoholics Anonymous program, and the suspended lawyer has his own lawyer and is going to go to be interviewed by the bar officials, and you're his lawyer. And as his lawyer, you're not sure that he's gone to the meetings as required. And so what you're thinking of saying to him is this statement, which is, I hope you went to AA as required. You may be asked about it. I'm sure you know there are 12 steps, and just to refresh your recollection, these are the 12 steps. And you list them. Anybody here think that that's ethical? What do you think?
Less than 1%. In the group?
I believe in this instance that the only reason that any lawyer would do that is to educate the client and enable the client to lie. about being there. That if you really wanted to have, certainly you'd ask one question first, right?
Did you go?
Did you go?
Did you go?
And the second question would be, then if you went, tell me the 12 steps. And suppose that your client says, I can't remember any of them.
After the client said, yes, I did go.
Yes, I did go. Tell me, I can't remember any. Now,
Well, alcohol does have a way with the memory.
I know that's the problem, right?
Yeah.
This is the AA
But
no
on a
alcohol.
serious note, let's say the client said, no, I did not go. You know what, I really messed up and I didn't go. I failed. I mean, what's the path for the lawyer? Is it, the path for the lawyer kind of obvious to get some time to send the client to the real meeting before it has to report back? What?
But I don't think anybody have a problem with that, would we? Client said I didn't go, as lawyer to say, well, let's figure out if we can get you an extension so that you can actually go. Because it's really important. I mean, if you want to get your license back, you got to do this right. I mean, I don't think anybody have a problem with that. So the line here, so people say, where's the line? I don't know, a few people in this room are as old as some of us and will remember the movie Anatomy of a Murder. It's a good book and it's a really good movie with Jimmy Stewart being the lawyer. If Jimmy Stewart's the lawyer, you forgive him, right? For whatever he's doing in the movie, but he's got Ben Gazzara as his defendant. And Ben Gazzara's wife, Lee Remick, was raped. And Ben Gazzara goes and shoots the bartender who raped her. And when interviewed by Jimmy Stewart, and asked what happened, says what happened, and Jimmy Stewart says, well, the only defense possible here is temporary insanity. And he says, in order for you to have been temporarily insane, these things would have to be true. Ben Gazzara says, well, they're true. And they put on the defense, and actually, one of the interesting things about the movie is that you really like Jimmy Stewart. You don't know about Ben Gazzara, but you really hate the guy he shot. And in Texas, they have this, this defense that you can't use, I guess, in some places that the decedent needed killing. And you kind of get that message in the movie. But so the question is, where's the line? And Bob wrote about this in an article you have in here. Where's the line between you're planting something in the mouth of a witness that you don't have sufficient reason to believe is true, versus you're telling the witness the elements, as we talked about, and asking whether or not this could be true. And that line is basically in the mind and the soul of the lawyer. It really does come down to that. If you have reason to believe your client went to those meetings and your client is just a nervous wreck, and you have a way to try to probe that, then those of you who said, yeah, I think I can do this, I think would be acting ethically. If you did it, though, because you didn't want to know whether it was really true that your client went and you wanted to avoid that question, I think you got a problem. Although, let me just drop a footnote to that. On the criminal defense side, some of you do that. The majority of criminal defense, I do some criminal defense, but I'm on the minority side of dealing with clients. The majority position is you don't ever ask your client to tell you fully and completely what happened, because that keeps all your options open. My approach has always been different. I say to every client, I want to know exactly what happened. I'm going to press you for the details. And the reason is that you're not the one to decide whether there might be a defense. If you keep something from me, you might lose a case I could win, or you might disable me from getting you the kind of deal you could get if I only knew the facts. And that fluid position, I don't want to know whether you did it or not, is one that always has made me nervous. But if you're on that side of the I'm never going to ask, you have, I think, probably more freedom to throw stuff out there and then claim that you weren't putting words in anybody's mouth. You didn't have any reason to believe that what you were saying wasn't consistent with the vague story your client told you.
Okay. Question in the audience over there.
Why wouldn't you just contact AA and ask them to certify whether you attended?
Why wouldn't you just contact AA and just ask them to certify whether or not he or she attended? Isn't there a privilege there? A
lot of people in AA won't do that.
Right.
Yeah. So
The identity of people at the meetings and, whether you attended is really something that they won't turn over.
it's experience up here talking.
That's right.
All right, let me switch to an area that's, I think, a fascinating area, and it's in hypothetical number 7, and it's really something that nowadays you hear a lot about, and that is how do you professionally prepare your witnesses. So here you have a lawyer and a client are rehearsing testimony, and then you let your client, I will take this in 2 parts, you videotape your client and you cross-examine them or you direct examine them, and then you sit down and you watch it with them. You know, are there pitfalls in doing that? Now, this is with your client, and I'll throw out the answer, and the answer is no, there are no pitfalls in that. I think it's great lawyering. I think that spending time with your client, showing him or her how they really look, what facial expressions they're making that they don't realize, you know, just like poker players who have a tell that they don't really understand, and through facial expressions, voice inflection, body language. I'll put it out here, I've done it, and it's been terrific with the witnesses. Clients, I want to get to non-clients, but
let's start out with your client.
Yeah.
Okay. There's no doubt, and I think in my mind, I agree with you that it can be very helpful to show someone how they sound and how they look. Most of us are shocked when we see how we sound and look the first time, and it's so I think there's an upside. The downside potentially is this: that it's back where we were before. Depending on what court you're in and what judge you have, the question is that viewed as something that was shown to the witness to refresh the witness's recollection or prepare the witness to testify, in which case it's disclosable.
Once again, this is our client we're talking about at this point.
Yep.
I'm going to get to the witness, a lay witness or an independent witness.
Well, what I said is, now, I can't speak to Illinois State Court, but there's certainly federal court decisions that say, even as to your client, if you're showing something to your client to refresh recollection or prepare testimony, then you got to be prepared for the possibility it'll be turned over. So let me ask you this.
You got to fight that one.
Yeah, but
Yeah.
So let me ask you this question, Bob. I'm serious about this.
Yeah.
If you had a judge that you knew had ordered videos, even of clients, to be turned over in past cases, and that could happen in your case, how would you do the cost-benefit analysis? The benefit to the witness versus the risk that the other side would use this.
I probably wouldn't, but you know, in a system where, for an example, here, Judge Flanagan is deciding a lot of the motions up front, and then now I'm getting to a trial judge, and I don't really, but you know, a lot of time has elapsed, 18 months of time, 2 years of time has elapsed, and I'm preparing my witness for trial, and I don't know who my trial judge is going to be until the day of assignment. So you may not know those things, but to my mind, showing a client him or herself on a video screen to show that their facial expressions are hurting them, I don't think that's different than showing a witness a document.
I think that falls within your trial strategy, your work product, your rehearsals. I don't think that's discoverable at all.
I would take the contempt on that one. And
Absolutely.
and
I don't think that.
But now let's turn to the independent witness. I think that's discoverable, personally, and I think you'd have. So if I bring in, one of the things about the Circuit Court of Cook County, if you look at the witness chairs, if a witness sits on the chair and if they don't put their arms on the chair armrests and they're like this, from the back of the courtroom, they look like they're closed and they're grumpy. And so if you are preparing a witness and you're showing them stuff like that and then you're videotaping that might be discoverable.
So let me ask you on that. I think you're right. Because I'm not sure we're clear about one thing. We ought to be clear. What's the downside if it's discoverable? What are we worried about? It's not ethics. It's how it's going to play out when the jury hears about it, right?
Yeah, that's how it's going to play out. And that goes to that litigation credibility concept. Do you lose your... well, this goes to the next part on a related question, because this is where the good one comes in. Now you got a professional coach doing this, okay? And there are people who, just look in your trial magazine and look at your National Law Journal, and they're advertising themselves as trial consultants, and they got psychologists who are helping prepare your witnesses to testify. you know, how much of all of that is that work product if it's with a lay witness, or is it a work product if it's a client? And there's a big difference between those two.
Well, Angela's asking along those lines, what if you prepare a document?
So,
and
so,
give
so
it
from the web, a question
the
from
web,
Angela.
right.
Okay,
Angela's
what's the
asking,
question?
is it improper to prepare and provide written questions and answers in a document, allowing the client to review it, and then take it back and destroy it and not retain any copies?
Well, that one, can we go back to Angela's question, stay with Bob just for a second
Yeah,
before we
okay.
lose this one? I know that in a great case that you won involving the violinist who was injured on the
Right.
Chicago train, you used a coach for the plaintiff.
I did.
And, I mean, it turned out to be a very important piece of that case. And I think you made a judgment that that was really important and it really worked out well. I mean, worth just giving them a brief description of how that worked.
Well, okay, and what I say with the permission of the client. She's been very supportive of letting people learn from her experience in all ways. So we prepared her with video and just lawyers, and we showed her how she looks on video, and we had a coach that we worked with who gave us tips about how to say things, how to dress, how to act properly in a court of law, and it was all very helpful to the case. And if anyone had ever asked me for it, which they did not, I think it's privileged. It's certainly part of the core work product. I think there's a world of difference between with your client and with a witness. Big difference. But it can be a very effective tool. And, you know, this all goes to what Judge was talking about before when she's reading these depositions, and it's clear that the witnesses haven't been prepared. You know, we are not barristers, okay? Barristers don't want to get their hands dirty by talking to the real witnesses. They rely on the solicitors. And they are stunned by how much time American lawyers spend with witnesses in preparing them. But the fact is that you want to be an effective trial lawyer, there's an ethical, proper way to prepare a witness and spending time with them. But there are certain rules of engagement, and you got to follow them. But it's going to make a difference in winning your cases and winning them ethically and professionally.
And Julie
Question
is
from the
asking,
web?
we have lots flowing in here. Julie can barely keep up. Julie is asking, is it unethical to under-prepare your client? For instance, if you go into a deposition and they can't remember anything, and then they review the documents the night before, and the witness goes on trial and remembers everything. Is there a problem for that attorney?
I think there's a problem because the client then will come across as being an impeachment bonanza for the other side. You know, that, oh, when you were at your deposition where you asked this question and did you give this answer and you didn't remember, but conveniently you remember now, it looks like the client didn't remember anything but was coached now to create the most positive, most beneficial version of events. And that's going to look bad. That's really going to impact on the credibility of the witness. And
that's where I think in these times, lawyers really need to spend a lot more time preparing their witnesses for depositions. You have to make the time. The days of bringing them in the morning of for a 2 o'clock dep are gone. It just does not work.
Eric is asking, though, what about a lawyer's obligations regarding a witness who intends to lie at his or her deposition? Or one when you suspect that he might lie at the deposition, what are the lawyer's ethical obligations?
So in other words, the question is that you know that a client or a witness is going to be untruthful, that they deliberately try to find a way to lie.
What does the lawyer do?
Well, what we know is that the ethical rules are clear, that you're not allowed to support or suborn false testimony. You're not allowed to try to create false testimony. So if you knew, if somebody told you they were going to lie in a deposition, one of your options would be to move to withdraw. If it was your client, to move to withdraw. If it was an ordinary witness as to whom you own no obligation, I mean, you may choose to alert the other side that this testimony, in your judgment,
well, wait a minute. Let me talk about that. So now your client comes into the office, and the client says to you, I'm going to do my dep, but I got to lie about this one. I can't really tell, okay? I agree with the part about getting the continuance, okay, until you sort it out. But B, I think it's wrong for you to call up Leslie Rosen over there and say, Leslie, I'm canceling the dep today because my client told
No,
me
no, I agree with
lie
that.
about it.
No.
I thought it was a witness. I thought it was a witness we were talking about.
We were talking about.
That
Well,
witness.
even with, frankly, I don't know that you want to do it with a witness. Would you do that to the, would you say that to the witness? Is that proper? I don't know.
Well, actually, if it's not if it's a witness that you have no responsibility for, let me just take a step back and say you may have no obligation to do anything, because what you probably can't do though is start asking questions at your turn in the deposition
If you
to
know.
further bring out false testimony. But if the other side brings it out and you know it's false and you're sitting there saying, I haven't done anything to encourage this. I tried to discourage you.
No, come on. No, here. Let me give you the real fact pattern, okay? So
He's
now
changing it on us.
there's an independent witness going to be subpoenaed for a dep, 2 o'clock, shows up at your office. You call the witness ahead of time and say, hey, will you meet with me ahead of time and talk about your testimony? Sure, but I won't do it until 1 o'clock. So the witness shows up at 1 o'clock, and the witness discloses to you information that she admits in her conversation with you is a lie. And you say, whoa, you stop the discussion, you say, I'll see you at the dep. Now you're at the dep, and you hear her lying.
Yep.
Are you saying that it's your right to stand moot and not ask about that or bring it out? Or?
Actually, you have no obligation to that witness.
You have no obligation to that witness, but you have an obligation to the court in the case.
Let me just draw a distinction between, because there is some case law out there. One thing's clear: you can never present that deposition and ask the court to rely on it, because that would be using what you knew to be false testimony. There's a debate out there as to whether you have to take action to correct false testimony in a deposition that you have not done anything to create and you haven't relied on in any way. And that's a tough one, right? It's a tough one because what do you think?
What do I think? I would always take the high road. And I would say, look, you and I just had this conversation. I think I have an obligation to go to the other side before we start the deposition and say exactly what you told me, because I don't want the other side to be at a disadvantage either. You're a free witness. We can both use you. We can both disregard you, whatever. I would never allow a situation to go past without revealing that, because there is no benefit to it, there's no upside, and there's a possible downside, especially if the witness then gets on and says, well, I told him outside that all this was going to be false. Then where have you put yourself? For somebody that isn't even your client, who you don't really care about anyway.
Well, you put yourself right against Model Rule 3.4 that's on the screen and in the materials.
You can't assist, but let me ask you this. Suppose the witness, the non-party now, not your client witness, says, I never said that to you. And now we have this issue. Have you made yourself a witness? Have you now a witness in the case? Because if this person does testify, the other side's going to want to call you and put you on to say the witness told you. You're going to say the witness told you that the witness is going to testify falsely. The witness denies that. Are you a witness? Do you want to put yourself in that position?
Well, but the thing is, if you do it right away and not let the situation lapse where you have the whole controversy coming later, if you walk right in and say, look, this is what this witness just told me in the hall, I don't want any part of it, clear it right there. And if the other side chooses to go with that witness's testimony, then they do so at their own peril. But you have, made the disclaimer immediately, which is the sooner the better in my book.
All right, question from the floor, Leslie Rosen.
Let's say we take the professor's approach and we don't support it, we don't do anything, we don't use it, we don't present it to a judge, but the other side then does use it in a summary judgment motion. Then what's your obligation?
Well, then that's where the professor just became a witness. It seems to me.
So I think that's a big problem. I mean, one of the things about our hypo is a little unreal. Is the person who comes to you to tell you that they're going to testify falsely is usually trying to tell you, I'm going to help you.
Right.
And that's why they told you that, and you're telling them, I don't need that kind of help. Right? All you're doing is putting me in an impossible situation.
Yeah, but now they got mad at you because you told them that, and
exactly.
now they go to the other side and they lie again.
So, but
See,
we have
There's a different part of the deposition to support.
There you go.
Something.
There you
but
go. Isn't that like the beef stew? Once a piece of the meat is found to be rancid, it's all bad. Isn't that the argument going to be? All right.
Well, we have Angela's question that we promised that we'd go back
All right,
to.
Angela.
Which is, the question was, What if you have scripted
Scripted
preparation?
notes, and then you destroy them.
Can you and you've prepared
Right.
use them to prepare a witness? Let's say it's not your client. Start out with, so we avoid the privilege issue for the moment, and you destroy the script. And suppose you advise the witness to destroy the script too. Have you committed an ethical violation?
Yeah, I certainly, let's give this some legs. All right, it would be, let's say it's a nurse and a hospital lawyer, prepares the nurse that way, prepares all the nurses that way, and now we're on our 5th nurse and we finally find out about the script. And so we go after the script of this nurse who's an independent witness, if you will, not a client, let's avoid the privilege issue, not a defendant in the case. Not only don't we have an ethical issue, we've got a spoliation of evidence issue. Judge? Come on, Judge.
No,
Spoliation.
we
They
don't
destroyed
have
it.
a spoliation of evidence issue. No, we don't.
Why not?
Because spoliation is the loss of something that causes you to be unable to prove your case. Now, how can a script, if it's destroyed, cause you to lose the ability to prove your case?
So
It
Judge,
doesn't.
let's tease this out a little bit. Let's take it in 2 steps. That Bob's hypothetical, the 5th nurse, and now you realize there was a script, okay? And you move in discovery for production of the script. And the other side says, well, I don't think I have to turn that over. It's work product. And it comes before you, and you rule you have to turn it over.
I would.
Now, then the party that refused to turn it over says, well, Judge, I have to confess, I destroyed it. Now, whether we call it spoliation or not, are you going to give an adverse inference instruction? That because this was
501
destroyed?
instruction?
Well, I don't know if it would even be a 501, but you can't order somebody to produce something that they did destroy. But I think it could be brought up at the time of trial that weren't you rehearsed? Weren't you, when you testified at your deposition, did the lawyer prepare you ahead of time? Whatever. I don't even think
And
there's a
didn't you
privilege.
destroy the notes?
And didn't you destroy
For
the
those
notes?
of you who aren't familiar
Right.
with the 501, because we do have some out-of-state people here, that's the Illinois Pattern Jury Instructions number 5.01, which talks about failure to produce evidence. In this case, it would be the failure to produce a document, and you get an adverse inference instruction because of that.
So that one more twist on this, so that this is real. Some of the lawyers I know who use videotape have thought they've solved the problem of turnover because if they videotape a witness on several occasions, they always play over. They always tape over what they previously did. But it's the same issue. If the tape is discoverable, if it is not, forget the party for a second, if it's discoverable and you've taped over to avoid anybody ever seeing what you previously did, you got the same issue. Have you, in fact, destroyed something you were supposed to preserve? And if you ask me this question, is the law clear out there as to what you're supposed to preserve when it comes to videotape? The answer is absolutely not.
Okay, we have a question from, first off, we'll have a question from the web, and then we'll have a question from the floor, and then I want to turn to a new topic, expert witnesses.
Joseph asks an interesting question about when ISME hires the Illinois State Medical
The Illinois State Medical Interinsurance
Exchange hires lawyers to represent treating physicians in medical malpractice cases for depositions after the statute of limitations has run. Then the lawyer for the treater talks to the lawyer for the defendant, who learns what needs to be said to defend the case. Can this be stopped by some sort of motion, particularly if you use HIPAA? And is it ethical to do this for the defense?
I think it's a little bit of a convoluted question. I know you crunched some of that up, but I think what it goes to, Judge and Professor, if an insurance company for a doctor represents insures non-defendant treating doctors, if the non-defendant treating doctor is subpoenaed for a deposition, what's happening is that the insurance company will assign a lawyer to that doctor, the subpoenaed doctor, and while they will likely deny it, there's certainly a reasonable belief that the lawyer for the subpoenaed doctor and the lawyer for the defendant doctor are having a friendly chat, and I'm sure what some might argue to be a joint representation deal of yours that you said you liked before. Well, do you like it in this one? Do you like it in this one, where they're basically communicating through the lawyers arguably violating HIPAA, who knows, we don't know. But that's what's going, it's a practice that's taking place here
Well,
in Illinois.
And it also, not only is it a violation of HIPAA, it's a violation of Petrillo that is still around in good law. I mean, this is a non-party treating physician whose services regarding the patient are not at issue in this case. And in that situation, if the conduct is not part of the underlying case as far as liability is concerned, then any discovery or any communication with that treating physician has to be done within formal discovery. It cannot be done outside. Now, I agree with you. I think it's a Potemkin village that, you know, they're kind of putting up there. And I think it goes on, but unless we can prove it, we can't do anything about it.
There you go. Okay, let me, a question from the audience and then a new topic.
Yeah, I had a question about the scripts. We've been talking about you writing out questions and writing out the answers. Is it still considered a script if I write out the questions, I pose the questions to my witness or client, I write down the answers they're giving me, just for my own purposes? So I can say, okay, this is how they answered it. I would need to follow up because they didn't give me the answer I was looking for. But I never provide that to the witness. I never provide that to my client. It's something I keep so that when I'm asking questions, either in a deposition or trial or whatever, I know what they've answered before. I know if I need to follow up. Is that still discoverable, or is that considered work product, even though you discussed those specific questions with the client or witness?
I would be more inclined to say it was much closer to work product because the witness himself is not using it. It's you that's using it to refresh your own recollection of what you need to ask and what further questions that you need to bring out. But as long as the witness hasn't seen that or used it or have had any benefit of it himself or herself, I think you're much closer. And as long as you don't use it at the deposition to say, well, when we had this interview, then you said this. Once you open that door to use it as something at the deposition, separate from yourself, I think that's when you cross the line and you would have to turn it over.
Okay, one brief follow-up.
Just as this follow-up, what if you have a privileged document? You don't want to show it to the witness, but you need to discuss the contents of it. Can you do that, not show it to the witness, and keep your privilege?
Well, it depends, though. What kind of content are you going to be talking to the witness about? Because if the witness is going to be testifying in the deposition, but the document is just something that is confidential with you and your client?
Or to refresh recollection.
If you use it to refresh recollection, it's going to come out.
But you've never shown it.
Maybe I can.
Well, yeah.
Professor?
Let me do both, okay? I can't imagine ever the notes that you make in the course of interviewing an ordinary witness ever being discoverable. That's classic work product. I mean, I think that your question is...
But the follow-up question where you're reading off of a privileged document to refresh memory from the substantive content of the document.
It depends on how you do it.
Right.
If, for example, you say to the witness, let me read something from this document to you, and then ask you questions, you've now disclosed to a third party privileged information, and you got a problem. If you haven't done that, you said, I want to ask you some questions about an event. You don't mention the document at all. Of course you can do that.
Right.
And to see whether the witness's recollection of the event is consistent with what you have in a document that the witness has never seen, and you haven't disclosed its contents. Remember, you're entitled to talk to people about things you learned about in privileged communications, as long as you don't reveal the privileged communication itself. And so you can do what you want in many cases. Now, if what you really want to do is you want to say, I need to read you this and see whether you agree with it, you got a problem.
The trick would be not to bring the document at all, but just make yourself notes on what you would want to ask the question about, because the notes then still stay within your own work product, and the document is nowhere to be seen. But the trigger mechanism that you're searching from the document is now within your own notes. Okay, don't even bring the document. Just take what you want off of it and put it someplace.
Okay, so let's turn now to a topic that's really a hot topic in both state and federal courts across the country, because not only have there been changes in the federal rules pertaining to expert witnesses and how you work with them, but many states are adopting the federal rules, so certainly the body of case law from the federal system is going to trickle its way into the state system. But here in hypothetical 8, and it could be any case, it says here, of course, a business tort case, but it could be anything, any kind of litigation seems to me. And can you tell the expert that you don't want any emails or correspondence between you and she, that all your communications have to be oral, and that you don't want the expert taking notes of any conversations? Now, I got to tell you, we'll talk about whether you can do that, but that's sure going to be one stilted way of working with an expert. So let's talk about this. Professor, what do you tell everybody now? You're more than familiar with the federal rules. You helped write them. So let's chat about this.
Fortunately, the changes, I think, are really healthy.
Can we talk about that?
Yeah, this is an exam. All of you who've dealt with experts know, and those of us who've served as experts know, that this, in the past, lawyers were always worried about early drafts getting disclosed, and you get deposed about an early draft, often before you'd seen all the documents. You're working on something, and the people try to ask you questions in a deposition and even in a trial about why it was you said this in an early draft, and your explanation is it's because I said that before I had read the depositions of other witnesses and learned that certain things I assumed to be true weren't true, and it just ends up being a mess, a holy mess. So under the federal rules, as they now are in some states adopting them, your basically drafts are not discoverable anymore. And a lot of the worries that would give rise to instructions like this are really not so much a problem anymore. And so if you, the lawyer, have questions that when it's a draft and you have questions you want to put on the report, pretty much the communications between your expert now are okay. They're not going to be disclosed, and you don't need to go through all this secrecy. It was before these changes that lawyers were really worried that their experts were going to get hung up in depositions on, changes, and they basically, so what happened, it was really kind of, you've done this probably, what really happened is, it was like the immaculate birth of a report. The expert would be on the stand and said, are there any other previous drafts of this report? No, there are no previous drafts. I was editing as I went along, but this is my report. It's my only report. And meanwhile, there were all kinds of communications, oral, that went back, but no record, nothing the expert could said to have been considered in writing that could be discoverable. And everybody knew this whole thing was it was in some ways much more dishonest. The idea of the immaculate production of a report than a lot of other stuff we did.
And not only that, there were times when they tried to say, okay, well, we're both on a computer screen looking at the same document, and we're tinkering with the different iterations of the document. Now they want to do computer-based research to get your metadata to see what was there before.
Right.
So, Judge, what are you doing in the state court system, though? Because not every state court, is the federal system. And what are you doing here? I go in, Dick Donahue shows up, and he's trying to get Barry Goldberg's every iteration of a draft report that Barry has from his expert, and what are you going to tell these guys?
Well, we do get a lot of litigation about this, actually, and most of the time people are pretty aggressive about what they want. They want every bit of communication. But somebody once raised the issue to me, and I think it's worth thinking about. Until you answer your F3 interrogatory disclosing the person as an expert, okay? That's when you formally disclose him and identify him as an expert, and then, you produce the report, if any. Up until that point, he's really still a consultant. And the communications with the consultant, until they're actually going to be a witness for trial, a consultant's communications and theories and letters back and forth, they might not be discovered.
But that's escaping the question. The question is, so now this expert who had 4 iterations of a draft goes from being a consultant. Donahue finally massages it the right way, and he got it right. And Barry, I keep calling you Barry Montgomery. I'm looking right at you, my buddy over back there. Anyway, Barry Goldberg's in there, and he's throwing a tissy fit because you won't let him have the 4 iterations of Donahue's draft from the consultant that finally became the expert's report.
Well, the
does he get them or doesn't he?
No, he doesn't.
Okay, got it. All right, so in a related light then, that same expert is going to be talking to you, and now he's going to be reading depositions and taking notes from those depositions and And are you going to be giving them all of the notes from the expert? What are they entitled to get from the experts, or can the lawyer kind of sanitize the file? Can the lawyer of the disclosed expert, can he go through the file and take out everything that he self-help decides is not relevant and discoverable? What's the process? What's the right process, Judge?
Oh, me? Well, it's kind of, it's a difficult process, but I think when I'm faced with that issue about whether or not the expert has prepared notes when he read depositions, if he's going to be using those notes to help him testify at the time, you get the notes. If he's not going to be using the notes to testify at his deposition, you don't get the notes. So it's a matter of what the use of the notes. If he's using it to abstract depositions and then using those abstractions to compile his report, no, that goes into the report, and the report is what is going to be turned over. However, if there's notes at the time of the dep, you get the notes.
Professor, you, not only because of your work in as a special master, but also as a litigator and trial lawyer, what have been the ethical stumbling blocks that you've come upon in dealing with expert witnesses?
Well, I thought the one I used to hate was this production. The expert would swear there were no drafts of a report prior to the, and I used to hate that. I had a case in Florida. It was a antitrust case in which the state of Florida was suing our client as well as other people for price fixing. Bid rigging was what the allegation was, and there was a lot of that going on. Not our client, but a lot of others. And the state of Florida, on a damage issue, produced this incredibly complicated regression analysis of contracts for highway paving. And their expert was asked this question in his deposition: did you have any draft reports of this regression analysis? And the answer was no. And we said to the judge, it's not possible. First of all, the definition of a regression analysis, as far as I'm concerned, is torturing the data until they confess. And that's what they are. And there's no way you could have a 25-factor regression analysis that he sat down and wrote and had no drafts on. But that was a huge problem of not being able to know sort of what was going on. Today, at least, we now know that the expert doesn't have to pretend. And the expert can honestly say, yeah, there were drafts, and I considered comments from counsel on, and so on. And at least you're going to get honest testimony. One thing you won't get right now, and I suppose, Bob, some people think it's a disadvantage. You'll never know what notes the lawyer gave, right, on drafts to the expert. And leads to our next problem. You'll never be quite sure how much of what an expert says is what the expert came up with and how much it's what the lawyer came up with. And that's a problem.
Well, that's where the question becomes, can a lawyer, and frankly, not only can a lawyer, but is it advisable for a lawyer to, in essence, draft the expert's report and say, this is really how you ought to say it and what you ought to say, and these are the points you ought to cover, and is that okay to do with an expert?
I once thought that my answer to this would be, if I'm an expert and I have to say the lawyer who hired me wrote my report, I'm done. So I have to confess this to you. Reason I'm flying back tonight to Washington, D.C. is I'm supposed to be testifying in a legal malpractice case tomorrow. The case is put over, but here's the thing. The lawyer who hired me called me up one day and we talked about the case, and he filed the summary of my testimony. And I was asked in my deposition, did you prepare this report? This was filed, and I said no. He said, did you read it? I said yes. And he had no problem with it. They had 3 experts, and same thing, their lawyer filed the summary of what they were going to say. And I really was troubled by this until I realized that apparently in Superior Court in Washington, D.C., nobody has a problem with it. The reason I was really worried about it was there are federal cases that say under the federal rules, particularly Federal Rule 26, that if the expert didn't write the report, expert testimony is not going to be admissible because the rule says it has to be a report prepared by the expert. And some of the federal judges have taken that quite seriously. And I don't blame them.
But can't the lawyer, let's stay with that because it's really important. Can't I, as a lawyer, let's assume in a federal case, and that's a witness who's never really worked a lot as an expert. You know, I don't know what a report looks like. Why don't you give me a first cut or a draft or something that I can tinker with, and yeah, I'll do that. And then I get that as I'm the expert, and I tinker with it, and the product that I release, I claim as mine. Isn't that the same thing, even though the first suggestions came from the lawyer? What's wrong with that?
I don't think that there's anything wrong with a lawyer making suggestions to the expert how to put in the report certain things that are going to be crucial. But I think when you actually get to the affirmative act of actually drafting the report, I think that's where you cross the line.
Yeah, I love your hypothetical of the novice expert who says, I don't know what a report looks like. And the lawyer's response is, I guess the only way I can show you what a report looks like is to write it for you. Come on, give me a break.
Hey, come on. It could happen.
The,
You know, someone has to be first. It has to be a first time for them.
the only thing I can say, by the way, in my own defense in this case I'm testifying in, is that the summary of what I was going to say was so cryptic that it really didn't go into any detail. And when I was deposed, none of the substance of my testimony actually had been in that report. So nobody could say that the lawyer had anything really to do with the substance. But it made me nervous, and I would not want ever to be in a position, even if the rules allowed it, to have to say that lawyer who hired me, who's paying me, is the one who wrote my report, and I just adopted it. I mean, I don't think that makes you look like the neutral expert that brings credibility to the table.
All right, let me, I know we have some questions on the web, but let me stick with this expert stuff for a minute, because I want to talk about now you've gotten past the issues of the report, you've gotten past the issue of how to prepare. Now the expert, or actually it could be just the witness, I think we can cover all here. Now they're actually testifying, and they're on the stand, and or they're at a dep, and but it could be either. And you kind of, as a cue to the witness, say, "Now listen, Charlie. If you happen to hear me cough a couple times, you know you're screwing it up, and I want you to really reflect on what you're saying here." Can you do that? Is that proper? You're not telling them, whispering in the ear what to say. You're just saying, "Whoa, think about this." Can you do that?
I would say no.
Me too.
Okay.
Isn't it really? It's just a form of a different kind of communication, right?
Yes.
Yeah. And so if you're not supposed to communicate with the expert while the expert's being deposed and is under oath and answering questions, the fact that you chose a different form of communication doesn't get you off the hook.
All right, so let's go that instead of the two coughs meaning that they should reflect, the two coughs mean that we need a break. And in the break, you start to say, "Hey, you dummy, let's chat about this." So in other words, now, once again, the visual, there's a recess. It's whether it's in the deposition or a recess at the trial, a witness is off of the stand, and I want to differentiate between your client and the witness that you are calling and vouching for. What are the ground rules about what you can and cannot do with that witness while there's a recess in the proceeding?
So this is real. When I was deposed in this case, I mentioned when I was being deposed, somebody said, "We need a break." It wasn't me. And then the lawyer who was taking my deposition, the other side, said, "I want to instruct you that you are not to talk with your counsel, the counsel has retained you, at any point during this break." And the couple lawyers who were there who had retained me basically said, "F you." That's a technical term. They said, "We'll do what we want during the break." And I went out and we talked about the testimony and what it is that was remaining, what they thought I had still to answer questions about. And I wanted to know whether they were going to ask me questions and how long it was going to take, and we talked about it. And then, of course, we came back after the break, and they said, "Did you obey the instruction not to talk to your lawyers?" I said, "No." They said, "What'd you talk about?" I said, "We talked about my testimony. What was coming and what they might ask, and that was it." I mean, and on this one, the judge and I talked a little before we started. There seems to be an assumption that a deposition is kind of like a trial and that the person taking it can issue those kinds of orders. And lawyers have all over the map on what they think their obligations are here.
Well, we don't want to be all over the map. We want to be instructive and decisive. So we're at a dep. Now it's a witness, so are you telling us that it would be proper for a lawyer, defense lawyer, to talk to the witness in the middle of the dep, again, albeit in a break, or even a call for a break to talk to the witness, and that's okay?
Free witness, yes.
Free witness, okay. Now
Free
it's your,
witness.
now let's turn to trial. And I want to talk about the rule. And Professor's giggling because he learned about the rule in Charlottesville. So the rule is, I have a witness on the stand, it's my client, and we're at the end of the proceedings for the day, but the client is still on the stand, cross-examination tomorrow morning. And the judge says to me, counsel, I do not want you talking to your client tonight about the substance of the testimony that's being presented today. Can the judge do that to me? He says that's the rule here. What do you say, Professor?
Well, we know there's a Supreme Court case on the criminal side of this, United States versus Gators, which said that the defendant has a Sixth Amendment right to counsel, that an instruction not to talk to your client overnight interferes with the attorney-client relationship, violate the Sixth Amendment. The Supreme Court also said an instruction from the judge during a 15-minute recess, you may not talk to your client, was okay. So you asked me this earlier on the civil side, where there's no Sixth Amendment right to counsel, but there still is a right to have a lawyer, and there still is attorney-client privilege. Should it be any different? And my own answer is no, but I would certainly, this is one of those things, I would certainly want to say to the judge who issued that instruction, Judge, I don't think that's proper.
Yeah.
This is my client. I think I have a duty to my client to talk to my client about about these proceedings.
So the moral of the story on this one, I think, is that for lawyers who, on either side of the aisle, if your client's on the stand and the proceedings are ending, you need to have and you know you're going to be talking to your client, you need to have a clear understanding of what the court believes to be the rules of engagement. I, for one, agree with Professor Saltzburg. If it's my client, I think I've got an absolute constitutional right to talk to my client at any time, even during that 15-minute break. But it's different, though, Judge. What do you think when it comes down to a witness? You know, we've got those client issues because there's privilege there and right to counsel. But what about a regular witness? Can the court tell me that I can't talk to my expert? I had this once with an expert. Cross-examination, the expert begins tomorrow morning. Tell me I can't talk to my expert tonight.
I can't imagine a judge ever issuing that order, a state court judge. None that I know.
So Bob's laughing because I had this experience. It's frightening. I was trying a case in the U.S. Court of Federal Claims, and some of you know that's all bench trials, federal judges, and I was the plaintiff. And at the end of a long expert testimony, the judge said, "Let's break for the day," and we broke for the day. And I took my expert witness to dinner, and we had just a nice dinner. And I went back to prepare, and the next morning, first thing the other side did was they asked, and there was no judge gave no instruction at all. The other side asked the witness, "Did you have any conversations with your lawyer, with this lawyer last night?" He said, "Yes, we had dinner." And the judge said to me, "You didn't violate the rule, did you?" And I was going to say, "What rule?" But I didn't get that. I mean, I was so stunned that I didn't get the words out. The judge said, you know that you may not speak to a witness between the end of direct examination and the beginning of cross-examination. But since, the witness said you just talked about the food and all that, I mean, that's not a violation of the rule. And I left there thinking, God, where's this rule? I mean, this is one, and we raised it. How many of you, by the way, I'm curious, how many of you know that rule?
1, 2, 3 people in the room. Here, we've concluded that there is no such rule. But
it's an urban legend.
But you need to, again, you need to know the rules of engagement. You're going to try cases, rightly or here. A lot of judges may be wrong on the law, but they are not in doubt. So, you kind of need to know what she's thinking.
Well, Bob, one reason for raising this, by the way, it is there's nothing I don't think more frightening than to think that your license is about to be taken away from you or your case is likely to be stricken because of some unwritten rule that is passed down from generation to generation and you just missed one. I mean, that's where I was. So, I mean, the lesson for all of you is, particularly when you're out of your jurisdiction, you know, you're trying a case somewhere else, that it's one of those things you need to ask about whether, when there's a break, you have an obligation, and you finished an examination of a witness, you have an obligation not to talk. I mean,
Well, there's also, you always should know the court you're in. And the problem, though, is if you ask a judge, if the judge does have such a rule, you may be opening a door that may not want to be opened. So I think your best bet, if you wanted to find out, would be to ask other lawyers who have had trials in front of the judge to find out if that judge does have such a rule on restricting access to witnesses after the case is over. You wouldn't want to all of a sudden set a light bulb off in the judge's eyes by saying, hey, do you have such a rule? And no, but I didn't. No, but maybe I should. So yeah, we'll start now.
Okay. Questions from the web on this topic?
Yes, we have on other topics in general. What if Jonathan is asking if you represent a client who refuses to answer pertinent questions at the deposition? What's the proper way of dealing with it in anticipation of the dep? Also, if you have a petrified client who has been testifying one way and talking to one way and then testifies the opposite, how do you deal with a witness then who changes her testimony?
Well, let me take the first one, because this is actually a quite common occurrence, and I usually end up getting a lot of motions for ruling on certified questions and motions to compel answers, etc., when a witness is instructed not to answer. Now, let's take it where the lawyer is objecting and instructing a witness not to answer. First of all, you have to realize there is no ability to instruct a witness not to answer unless the answer to the question invades a privilege. That's the only time. The Supreme Court rules specifically say that evidence at a deposition will be taken over objection, meaning you object, you make your record, you let the witness answer, and then you come in on a motion for ruling on the objection so you can decide whether or not you could ever use this deposition as some sort of impeachment at trial. If it's relevance, if it's immateriality, if it's, whatever, tell the witness to answer over the objection. And as a lawyer, if your client is reluctant to answer certain questions, you have to instruct them that they are bound to answer. That is your obligation as an attorney. They cannot not give the evidence. Otherwise, they'll be looking at a motion to compel. If they still persist, they could be looking at other sanctions, which can impact their own case. So they have to be made aware of that. The proper procedure, if there is such an incident, is first of all, try to find a judge. From the deposition, call the judge whose case it's assigned to. If you can't reach the judge, call the presiding judge's office. They'll transfer you to a judge who's available, and you can get a ruling right there over the phone and then keep going with the dep. It's usually much easier to do it that way than to reconvene after a couple of weeks getting back into court or whatever.
Okay. I think also one thing that struck me was that if my client, I'm at a dep, and my client refuses to answer some questions that I think are pertinent, to my mind, I need to call for a break at a minimum, try to get in sync with my client. I think I have a responsibility to do that. And then, depending upon what the problem is, either try to rectify the problem or suspend or halt the dep, because I don't want to get jammed up with the court, and I think I have a duty to protect the client from him or herself. And there's a hand in the audience.
Yeah, that happened to me.
It happened to
I
me.
knew my witness. He was not answering as forthright as I knew that he could.
Was it your client? A witness wasn't answering as forthright as they could. I'm trying to repeat your question because you don't have a mic. So your client was
My
not
client,
answering the question as forthrightly as they could.
Right. And so
Will you get a mic to her?
I requested
There's a question over here with a mic.
I requested a break in the deposition.
All right.
And the opposing counsel just jumped all over me and refused a break, and I attempted to explain, why I thought a break would
So
be helpful.
opposing counsel refused to honor the break that you called. So the lack of civility we had.
Right, and then she would cut me off when I tried to explain
And,
why this.
and once again, this
is.
is your own client.
And this is my client.
So what did you do?
So I shut up.
You shut up.
She wouldn't let me speak.
Well, so
Well, you didn't just take your client and stand
Go
up and say
home.
we're leaving?
Go
Go
home.
home?
Go
No.
home.
The next time you go home.
Next time, go home.
Okay.
Just-
So tell us what, now we all want to know. The
Well, I
inquiring
didn't-
minds want to know.
I didn't want my client to have to come back for another deposition.
So what happened? The case
She
settled?
just continued the deposition, and she had to work very hard to drag answers out of him that would
So-
have been easier for her.
Okay, so the lawyer who was objecting to the break just had to work harder. They ultimately get what they want and the problem passed? Yes. Ultimately, okay.
So, but let's have the point here. You have every right
Yeah.
to not only go home, you don't have to go home. You have every right to say, I am taking a break, grab your client, and walk out. And by the way, and if the other lawyer starts to give that instruction, well, don't talk, it's the FU answer. It's that, then you're going to talk to your client. And what Bob said is, what a lot of us know is, particularly with nervous witnesses, sometimes a very early break, when they get to leave and go out, get a glass of water, breathe a little bit, sometimes they go back. And even just a few minutes, they're much more relaxed. I mean, it's that first sitting down there, taking the oath, first time they've done it, and they just are a wreck. And if you take them out, they come back, and the second time they sit down, often, don't you think?
I do.
There's a difference.
Yep.
And so,
Yeah. All right, we have a question on the right here.
I just wanted to point out, there's a case out of the Northern District of Illinois, LM Insurance Corp. versus a CO Inc., 275 FRD 490, which says that once a deposition starts, you cannot confer with the witness except as to matters of privilege. And I don't know that I've never had but that is, at least, there is that decision in the Northern District, which would say, no, you can't, during a break, talk to the witness about the proceedings. You can talk to them about lunch, but at least according to the magistrate, I think it's Magistrate Cole, it is considered it's a trial, and in the Northern District, you can't talk to your client during the trial.
Okay, so I'm getting a signal here that maybe your question, I'll take care of it. There's apparently a Fed Sup opinion by Judge Cole, Jeffrey Cole, who is one of our better magistrates here in the Northern District, and he says that you can't talk to the witness during a break except for matters of privilege. And we got to get Judge Cole over here and have a little chat with him. Okay.
We're not in Kansas, Toto.
All right. Let's have a discussion now about candor and discovery. And this one comes up all the time, and I know Judge Flanagan's chomping at the bit to tell us about a story, but here you are in a hypothetical that the outside lawyer goes to a meeting with corporate counsel, the in-house counsel, and the vice president of the company, and the short is that they want to take a very, very narrow view of what is discoverable and what documents are produced, and the only way they get there is by wordsmithing that is probably inappropriate. What do you do? And Judge, how about, have you had instances like this? Can you tell us about it?
More than you could probably count, because we have this on an ongoing basis. Every discovery request is answered with what we call shotgun objections. Overbroad, unduly burdensome, not limited in time and scope, not calculated to reasonably lead to discoverable or admissible evidence, et cetera, et cetera. It's the standard answer across the board. So the opposite party comes in on a motion to compel, motion to overrule objections. Then we have to slog through, well, what's this case about, whatever. We finally get some answers. But the answers are so microscopically parsed that it really doesn't become a response at all. Or the attorney responding will take such a limited, parsed view, and the whole case can go forward on the basis of what's produced at that point, and then all of a sudden later in the case there's an explosion because other documents turn up. Very common occurrence, absolutely sanctionable if you're on the responding end of that type of discovery. You have an obligation to go to your client and say, right, wrong, or indifferent, I have to have every shred of paper that remotely relates to this. And if, in fact, you want to argue that certain things aren't relevant, then you can do that. You can make a privilege log, you can set aside the documents, you can go in for an in-camera inspection and have a judge make the ruling so that you're not caught later on in a very, very bad position, which can lead to sanctions. And I don't like telling war stories, but there is one story that is really serious. It happened in a case involving a Chrysler van. There was a particular part of the motor that caused the engine to stall. The company was sued. The plaintiff's attorneys had asked for all of the discovery regarding testing and adverse reports and whatever about the particular motor and the particular pump and the engine and whatever. Magically, out of all the volumes of all the years of all the research data, the volume for the year of this van in question was the only one out of 40 or 50 that was missing. Okay, so we go all through the case, and we get down past plaintiff's experts, depositions, we get to defendant's disclosures, and we are now at a deposition of the defendant's expert, and he is the one that had the volume of the entire thing all along, from the very beginning of the case. He was the consultant. He got the volume when the case was first filed. He had all the research data, which was devastating. The plaintiffs found out at that deposition that he had that volume of information and data throughout the entire pendency of the case. The plaintiffs came in on a motion for leave to file punitive damages because they had all prior accidents in there. And they also wanted a motion for sanctions. I said, after I read everything, I said, absolutely yes. This is absolutely a nightmare. I defaulted them, struck all their pleadings, gave leave to file the punitive damages, and 3 weeks later, the case settled for $26 million. And no appeal. Now, that's an egregious situation. Are you going to get that in every single case of a pleadings being stricken and a default? No. But you should definitely focus on the fact that it is a possibility. It is a possibility if you are disingenuous about how you interpret discovery requests. So that's my war story.
And Professor, I think you were kind enough, and I think it starts. I'm hoping I'm right on this, folks. On after slide 112 on your materials, but there's a.
Don't let them look at it. I want to give them the hypothetical.
Yeah, no, okay, but I just want to tell them where it's at. There's a piece entitled "Honest and Ethical Communications" for everyone, and the professor's going to talk about.
Don't crib
this. Yeah, don't.
Here's my question for you. Let's make us a law firm, okay? And this is a real case, and we have a case in which we represent a company called Phisons Corporation. It's a drug company, and it manufactured a product called Somoflin Oral Liquid. It's a drug that was used to treat asthmatic children. And a little girl who was 6 years old had a fever. The family took her into her doctor. They gave her Somoflin Oral Liquid. She suffered permanent brain damage. It's going to live the long, long life with the mental age of an 18-month-old. Family has sued the drug company. They've sued the hospital. They've sued a clinic. They've sued the doctor. And the plaintiffs and the doctors cross-claimed against the drug company. And in the course of discovery, a very good plaintiff's lawyer, a very good doctor's lawyer, have asked Phisons, your client, for all documents relating to the drug Somoflin Oral Liquid. You met with your client, the inside general counsel of the company. General counsel of the company says, the only active ingredient in Somoflin Oral Liquid is theophylline. It's a generic. And they haven't asked for discovery regarding theophylline. They've asked for discovery relating to Somoflin Oral Liquid. So what I'd like you to do is you file all the boilerplate objections. They were all filed, relevant and too broad and all that, and tell them you'll produce all the documents that relate to Somoflin Oral Liquid. So you're the senior partner. You go back and you talk to an associate in your firm, and you say, this is what they want us to do. They want us to answer the questions that respond to discovery and interrogatories and requests for production, saying we'll give you all the documents that relate to Somoflin Oral Liquid, but we're going to limit our response to anything that actually says Somoflin Oral Liquid. No documents that only mention theophylline. And you say that's what you do. You agree, and that's how you respond to discovery. Now, my question is, have you acted ethically? What do you think? Yes or no?
No.
Well, I'm glad. I'll just tell you, this is the first time in a long time that more than 50% of the people haven't said yes. And the case, by the way, that it's a real case called Washington State Physicians Insurance and Exchange Company versus Fisons Corporation. I was the lawyer who represented the insurance company for this doctor, and we ended up establishing that a law firm that no longer exists in Seattle called Bogle and Gates had participated in suppressing 60,000 pages of documents in this case. I gave you the facts that related to theophylline. And during the case went to the Washington State Supreme Court, and the company had 12 affidavits, including affidavits from Jeff Hazard, president of the American Law Institute, 4 former presidents of the Washington State Bar, all of whom said that what the company did and the law firm did was perfectly proper. And first, not only was it proper, and that the fault lay at the feet of the plaintiff's lawyer and the doctor's lawyer for not filing a motion to compel if they didn't want more. Well, Bob knows I argued this in the Washington State Supreme Court, and I told the court that that's crazy. I said they had no reason to file a motion to compel because any reasonable person would have taken the assurance to cover theophylline documents. And in the course of this argument, we basically said if a used car salesman had done what they did, they'd be in jail. The opinion, which was it's a 1993 opinion, but it's still one of the most powerful ethics opinions out there, condemned what the lawyers did, said there would be sanctions. There were sanctions, the largest sanctions in the history of Washington State. A year and a half later, Bogle and Gates, which was then one of the most powerful law firms in Seattle, got caught again. Similar circumstance, this time in a federal court. This was state court in Seattle, in Snohomish County. This time in a federal court, got sanctioned $150,000 after I had sanctioned them $375,000. And within a couple of years, the firm imploded because the lawyers had to leave. They didn't want to be associated with the firm that was regarded as the unethical firm, and Bogle and Gates no longer exists. So that you all answered correctly. But I can assure you, that, and the judge sees this a lot, that lawyers have what I call an unlimited ability to rationalize and to persuade themselves that they can give a discovery response that anybody but a lawyer would regard as dishonest, and they can square it with the ethical and discovery rules. It's amazing the capacity for self-delusion we all have.
All right. Well said. Pam, do we have a question on this from the web?
We have a lot of questions here, Bob. One of them is asks, what if a witness is taking medication that makes her forget her testimony? Are there sanctions for the attorney not disclosing this, and what does this mean for the testimony that already has been taken?
Well, that's interesting, Judge. Yesterday, as we all know locally, there was a plea of guilty in a criminal matter in Chicago. No, I was surprised at it. The judge asked Congressman Jackson before he entered his plea if he had consumed any alcohol in the preceding 24 hours.
Right.
And I'd never heard that. Maybe, Steve, it's common. I don't know. But it speaks to the knowing, action that he's taken in terms of his plea, but also on it related, how about at a dep? If a client comes there, has had a couple of puffs to get settled down. What's the story? What do you think?
Well, in D.C., if you hadn't had a drink in 24 hours, you can't plead.
Okay.
They know there's something wrong with you. I think everybody here knows.
It's an impairment. What's the deal with impaired testimony?
Well, pretty early in most depositions that I've seen, and certainly when I've been deposed, one of the early questions is, are you taking any medication?
Right.
Or is there anything that would impair your ability to testify today? And once again, if the witness is not answering honestly, then you as the lawyer, have this question, are you going to do something about it?
Well, let's talk about that. Now you find out, your client's kind of zoned out and just gave an answer that is not honest. Let's go. I know we've been over this a bunch, but one more time. What do you do right then and there?
Right then and there?
Right then and there. You stop the depth?
I would. I would ask for.
Okay.
I'd ask for a recess. I'd go out, and I don't care what the judge. I can't imagine the judge who wrote that opinion thinking that justice is better served by not telling my client that you can't lie in a deposition and getting to go back and say I made a mistake, that isn't a better approach than doing nothing and letting it go on. It just doesn't make sense to me.
Let's have another question, follow-up
Yes.
question.
Ray is asking, if you have an independent witness who is about to testify to something that might be an admission of a crime by that witness, do either of the attorneys have an obligation to advise that witness of potential criminal liability?
So now we're at a dep, and let's just say it's a dep that it's an independent witness. None of us have talked to him, and in the course of the deposition, the witness now, unrepresented by counsel, is saying something that me and attorney Scott Beckman look at one another and say, whoa, this guy's just confessing to something. Do we have a duty to do anything about it?
Well, the answer to this, I think, the answer to the question is clear. You have no duty.
Right.
But there's a moral dilemma here, right? You know as a lawyer that if the privilege against, every witness has a privilege against self-incrimination. And you know that in a country where people don't always know their rights, that everybody should know. And that as a lawyer and an officer of the court, there's a part of you that wants to say, by the way, you have a privilege against self-incrimination. The problem is you also know the moment you utter those words, the other side is going to tell the judge you just obstructed justice by effectively interfering with a witness who had a right to make his or her own judgments without your help. And are you going to, now I don't think it is obstruction, but the question is, are you taking a chance? What do you
I think you take the high road again here too. I think you.
Well, what's the high road? Don't
The high
obstruct
road-
justice or help the witness
No,
out?
the high road is telling the witness, before you go any further, you really should understand that perhaps you should seek legal counsel, that you do, you may get yourself in trouble here, and I think, taking the high road is never going to be punished. Never.
the other possible approach to that is to stop and say to the other lawyer, let's have a conversation.
Right.
You don't want to ask that question. It's not fair.
You know what this, I have to tell you something, and I wanted to bring it up. I mentioned the word before, but one of the things we haven't talked an awful lot about today is civility. And Judge, I know you have some views about that. I have to say, just anecdotally, from what I see going on in the cases I'm handling and that the lawyers in my office are handling, I see a deterioration of the civility among members of the bar. And Judge, I'd like to have your take on what you're seeing and what you think we ought to be doing about it.
Well, I've been a judge 24 years, and I spent the first 4 years in divorce, and I thought that was nasty, which it can be. It can be very nasty. And then I came to the law division where I had originally started practice. And in over the 21 years that I've been in law division, I definitely see a degrading of the civility, the professionalism, the ability to work with the other side. There seems to be a mentality that is, adverse. This is an adversarial system, but it doesn't mean that you have to be antagonistic in order to be adversarial. You have a client to represent, but it doesn't mean you have to bash the other lawyer. You don't have to denigrate them. You don't have to accuse them of, not having a proper law license at a deposition. You don't have to insult them in order to get what you want. This is what is happening over and over and over in all kinds of cases. And the tone can be set at the very beginning of a case that then, if there's an antagonism in the beginning, it carries through and the entire case becomes an arduous trek to get through to what should be civil litigation. And civil litigation is not an oxymoron. It shouldn't be. It is, but it shouldn't be. And I think we have to get back to the more civil behavior, more professionalism among members of the bar, and more respect when it comes to court.
Okay, and
walk into court.
Thank you. How about let's get back to another question or two from the web.
Yes, we do.
Put them all together.
That'd be impossible. There's too many. But there is one regarding divorce you mentioned, Judge. In a divorce case where the parents pay for the son or daughter's case when they have separate attorney, and they're often present in the room, is there a risk of the attorney-client privilege when really the child is the client?
Well, when is the child the client in a divorce case?
When they've hired separate counsel?
No, I think what they're saying is that the child, who's an adult, emancipated person, gets married, but now mom and dad are paying for the divorce, mom and dad show up at the meeting with Attorney Saltzburg. What happens to the privilege? God bless you.
Privilege is gone. The minute there's a non-client in the room, privilege is gone.
Okay, go ahead. Another one.
Another one. There's also some questions here about abuses of breaks when they're taken after each question. But what about when you take a break when there's a question pending before the client and the client hasn't answered yet?
So there's the difference. So rather than it's, now we're in between questions now. Now, that's one thing. But now we're in the middle of a question. And you realize you have an oh shucks moment that you didn't cover a topic with your client or the witness. And holy moly, I don't know what the answer is going to be, and it might be bad. Time out, I need a break. Can you do it, Professor?
You're going to give you're likely to pay a price if you do with the judge, but if it's your client, I think you have to. You have to give skin to protect your client.
Okay. All right,
Another
one more,
question
Pam.
is, what do you do when the attorney learns after the testimony that the client gave false testimony?
I think you have a duty to correct it.
So in other words, so you agree with that, Professor? So client gives a yes, and you realize it should have been a no.
One of our good friends, great ethics professor, Larry Fox, spins out a series of hypotheticals about whether, until the time the deposition gets used, whether there is a duty for you to do anything until such time. And there's some disagreement among ethics professors about that.
Right, and because it could be used, the deposition is being quote unquote used for the decisions that are being made during the processing of the case, and so that's where. Well, we have time for one more question and then closing remarks by our two panelists.
Okay. There have been a number of questions about videos, but I guess I'll pick instead the one, is there a difference preparing a witness for pretrial versus mid-trial?
Mid-trial?
Mid-trial, what's mid-trial?
In the middle of a trial versus before the trial.
Oh,
Is the preparation of a client different?
Is the preparation different? Probably not.
probably not.
Okay, now settle down here. Settle down here.
Well, Russell.
Buzzer's about to ring. Buzzer's about to ring. Okay, Judge, 30 seconds. What's the best remark you could give us? Professor, you too.
Yes, thanks for attending. It was wonderful to participate. I hope you enjoyed it. Those of you who are around the Daily Center, if you ever want to stop by to run something by me, as long as it's not about a case on my call, I think most of you know that I'm pretty accessible, and I'm always happy to help lawyers in whatever issues that they have. So thanks for coming, and thanks for making it a success.
Professor, one pearl of wisdom?
Well, I'd just like to say, if there were more lawyers like Bob Clifford willing to put on seminars like this for lawyers around the state, you'd have more civility. And my guess is that those of you who take the time out of your own busy schedules to come and participate, whether here live or on video, are probably not the lawyers we need to worry about. But for those of us who are participating, thank you for being part of this. It's been a lot of fun.
And Judge and Steve, thank you. Ladies and gentlemen, we are adjourned. Thank you all very much for attending, and those of you on the web, thank you so much for being with us. We tried to accommodate your questions, and we hope we helped get them all in.
You'll be getting your CLE certificate as you leave the room, and please remember to fill out the evaluation form. You'll be receiving online here your certificate of attendance for CLE via email in the next few days. On behalf of all of us at Clifford Law Offices, we thank you for attending.
And thank you, Pam.